So, California Secretary of State has allowed Donald Trump on the California presidential primary ballot, and it joins Michigan and I believe Minnesota in allowing Donald Trump to be on the presidential primary ballot. We're still not seeing anything about the general election ballot. And we see that Colorado and just today, Maine are the states that have disqualified. One has been through the judicial review process of Colorado courts, and the other has been by the Secretary of State of Maine. So we're going to see how the states play out over here and how many states allow Donald Trump to be on the presidential primary ballot and how many states outright disqualify him. We're going to see uh, as the deadline comes for each of the states to submit the names of the people who want to be on the presidential primary ballot. Now, California has said what it's going to do. Michigan has said what it's going to do. Maine has said what it's going to do, and Colorado has said what it's going to do. Minnesota has also. Uh, it doesn't mean it's a win for Donald Trump so much so as each of these authorities in each of these states are interpreting their duties under the California Constitution and under the Michigan Constitution and under the various states' constitutions and interpreting the judiciary is interpreting its role in how to apply Section 3 of the 14th Amendment. Now, some states won't apply it, some states will, but whatever happens, this case of disqualification, because the Colorado ruling, and then because of Maine's ruling, and perhaps also because of Michigan's ruling, because of parties who want to pursue, even in Michigan, the case is ready to be reviewed on the merits, and the Supreme Court has of the United States has a very important decision to make at this time, whether they're going to hear all of these cases together, whether they're going to hear all of these cases separately. Whatever they do, they have a huge vested public interest. That's the policy in figuring this out, possibly before the primaries, if not the general election for sure. So it gives, I think March 5th is when the primaries start, and March 4th is when Donald Trump's criminal conspiracy trial is set to start in DC. And so it gives the courts, the Supreme Court, which will hear this case, about you know about a month and a half, and I believe that's plenty of time for the Supreme Court to come out and talk about it. And since I'm making this video, I have talked about disqualification for about as long as the scholars have made me aware, starting with Representative Raskin, Representative Jamie Raskin, and on to Judge Luddick, Lawrence Tribe, the Federalist professors who wrote the fantastic law review, and now the legal decisions, and also the official duty decisions, like in Maine, and the judicial decisions in Michigan. They are all pointing towards resolving this disqualification issue. So, one of the things that I wanted to bring up is also the enforcement clause. People have asked about this, so I want to talk briefly about that. So, the Section 5 of the 14th Amendment is the enforcement clause that Congress has the power to enforce the provisions that are mentioned in the 14th Amendment. But that itself is not a prohibition on states and electors in the matter of elections, because Article 2 vests that power to states, to Congress, states, and electors. States and electors have a role and duty to play in enforcing the disqualification clause absent any congressional action to enforce it. So, in that argument, there's a counter to that argument, and that counter to that argument is 18 USC 2383. And I just thought about that, because it's a possibility, because as my professor would say, the Supreme Court can do whatever it wants. It's a possibility that the Supreme Court can say that Congress did enforce its enforcement clause duty, and that is in the criminal statute of insurrection rebellion, that is 18 USC 2383. Again, 18 USC 2383. Now, that is a statutory criminal statute. And the argument against that argument, that the vesting has happened through criminal statute, doesn't cure fully the constitutional remedy that is present in Section 3. That is the argument that arguments for disqualification would have, is because in the matter of elections, in the matter of the issue at hand here, that states and electors have the place under Article 2 to have a say in how the qualifications are administered, which is the qualifications of whether you are qualified to be president or not. So it is an entirely convoluted issue that is one of first impression. And Colorado is the first state judicially to take the bold step forward, addressing justiciability, conclusively discussing the standing of electors under state law, which the Supreme Court can't review because it's state law. And so they take care of standing. They even talk about the political question issue, but they don't fully address the statutory enforcement issue, which I just talked about, and 18 U.S.C. 2383. And they also don't talk about the due process of law that is required, although the Colorado court makes clear that it uses a heightened scrutiny of clear and convincing evidence and not preponderance of the evidence, which is the case in most civil cases, to assess the evidence in the case of whether Donald Trump engaged in insurrection or not. So it gives the Supreme Court of the United States a lot of questions. And then now the question of whether Maine, the Secretary of State, being the officer qualified and the correct officer to assess presidential qualifications, decides that this person, based on my review of how we look at engage in insurrection, absent Congress's any sort of dictate on it, we have the authority, the states have the authority to seek whether the candidates are qualified to be on their various ballots or not. So that's a states' rights issue that Supreme Court has to take up. And, now Supreme Court has 4, I think 5 if you take Minnesota's denial, where 2 of them have gone for disqualification and 3 of them haven't. But I wanted to bring up that quickly about the enforcement clause because it is one of the other against arguments. And, I was taught to argue both sides or all sides of the argument. And one of the things that sort of inspired me to do that, interestingly enough, was a story about Chief Justice Roberts, that Chief Justice Roberts always looks at a case from every angle possible. Like he is reviewing all of the Michi briefs. He's looking at you know, both sides and of the you know, the plaintiff, defendant, petitioner, respondent, and the idea to hover over the issue and look at all of the sides of it gives the jurist, or gives the arbiter of in fact, with being the juror in the trial courts, the ability to be just in how they lend their opinion. So it'll be a, you know, this is Chief Justice Roberts's court, and uh, on constitutional matters, it'll be interesting to see how Chief Justice Roberts steers the court. Obviously, there's no like pressure campaign on other justices. They're all, you know, if they were to go into the merits of the case that he engaged in insurrection, if we cross all of these justiciability questions, questions of jurisdiction, then the questions of the enforcement clause and due process, just say all of those are now resolved, and the Supreme Court gets to the substance of it, saying that Donald Trump did engage in insurrection, and therefore he is disqualified, like Colorado Supreme Court holds. It, if it, you know, that question, it will have a profound impact on all of the states of the union. It will have, it will disqualify federally Donald Trump from the election. And lastly, I want to talk about one last thing, which is many people have come out and said that disqualification under Section 3 of the 14th Amendment is unconstitutional, it is undemocratic. And they have also gone out on a limb to say that even if, you know, he were indicted and criminally convicted of insurrection, that he wouldn't still wouldn't be barred from you know, running for office. The idea that we can just completely forget about the disqualification clause is a dangerous precedent that we set. And the profound impact of not resolving the issue of the disqualification clause is uh, is it gives people you know, does not give people who are going to go to the voting ballots the information they need to be able to properly assess how to vote. And uh, it is not undemocratic to bar somebody from the Constitution because they violate a qualification of the Constitution. Because the undemocratic thing is engaging in the insurrection. The undemocratic thing is not the constitutional remedy that cures or addresses the uh, the engagement in insurrection. So it is the engagement in insurrection that is undemocratic, not the provision of the Constitution or the law and criminal statute, which he has not been indicted for. It is about the Constitution. And the constitutional remedy is not undemocratic if it is applied by the states, because states have authority on election matters under Article 2. So the argument is open, and you know, I will leave it at that. And I don't want people to look at things as weaknesses and strengths, but as competing ideas, and then think of the best legal logical idea, you know. And the Supreme Court, I hope, will do that. And you know, my hope is that I'm able to provide you with some level of understanding of what is happening. And in the interest of that, I will stop now. So if you have any questions about um, what I said, please leave them in the comment box, or you may share them in the chat if I see them now. And other than that, I will not be coming on and talking about every state that allows Donald Trump onto the ballot. I will come out and talk about a state if they disqualify, because it would be informative to know about what the state procedure is, because in Maine it was the Secretary of State. In Colorado it was the judicial process, judicial review. So in that sense, Colorado's ruling is stronger. But uh, the qualifications, states have the vested power under Article 2 to, fill in the gaps of where there's a federal gap in how election qualifications are held. And so we have to move forward and take each of these perspectives and then assess what the Supreme Court will do. The hope is Supreme Court will give us a decision before March 5th, before the primaries begin, before Super Tuesday. And I hope that, they shed light on this, whichever way they think is the right way to go, because um, it is important for the American public to know the truth before the election season starts, and to have these matters of law and facts be laid out in front of them so that they may be able to assess the truth for themselves without anybody saying how they paint it. The courts are giving us various opinions, and the Secretary of States are giving us various viewpoints of how they are applying their state law, and all of them should be looked at, because on the matter of elections, there is nothing. On the matter of qualifications, there's nothing that Congress has done that addresses Section 3 of the 14th Amendment. It may be in the criminal statute, but it's not in the body of law that governs elections. And therefore, the state and the electors have the, the, the standing to bring uh, these cases and to have the ruling that Maine Secretary of State made. With that said, thank you so much for being here. If you like what I said, please like and subscribe. If you came late, please go back if you want to know more about what I was talking about. And if you have any questions that are longer, please leave them in the comment box and I will do my best to get back to you. Please like, subscribe, and I will see you soon.